Let's go on the record on cause number DC 207704, Eric Hambrick versus Illuminant Mining Company, LLC. Counsel, make your appearances.
Good morning, Your Honor. Kevin Queenan for Eric Hambrick, and I also have my law clerk, Victoria LaFleur, if the court doesn't mind, she's here in the room with me.
Hello.
Hi.
Alan Moore for Defendant Illuminant, Your Honor.
Okay. All right, let's, did you guys submit orders on these or not?
No, we did not, Judge.
Okay.
I didn't know you wanted them before. I'll do that next time. We did them after the hearings before last time, but my apologies.
That's just in this, while we're doing stuff remotely, it's helpful to have the orders pre-filed so we can look at them, but that's okay. All right, let's go ahead and proceed. We have two motions to compel today.
Yes, Your Honor. They both relate to non-parties. One of them relates to the deposition of Mr. Tommy Brown, and Mr. Brown is called here. Well, first of all, he missed his previously set deposition, but since that time and since we filed the motion to compel, he's called here, and we've agreed to take his deposition on January the 8th, 2021 at 10 o'clock at Jeff Weinstein's office in Athens, which is about halfway from Dallas to his house. And I thought he was going to join by telephone, but I know he has a little some technology issues. And so I cleared the date with Mr. Moore, and I think Mr. Moore was available. And so what we request is that the court enter an order on that, and I'll send it to Mr. Brown and let's see if we can get the deposition back.
Any objection?
No, Your Honor.
Okay. And your second motion?
The second motion, Judge, relates to Warfab Industries. We did provide them notice. Again, that's a non-party, and we did provide them notice of the hearing today. Did you want me to go into it, or since they're not here, did you want to just grant the relief? I'll do it either way. I don't want to waste your time.
I thought there was a response filed to this one. Is that not right?
There actually was, and we did provide them the links. I'm not sure why they're not online again. I don't mind waiting, or I don't mind calling them, whatever the court wanted us to do.
Why don't you just call them and find out if there's, just because they filed a response, it makes me think they're probably opposed.
I can do that.
Your Honor, while we're doing that, just as a housekeeping matter, we had previously filed a motion to substitute counsel on November the 10th.
Okay.
And with the proposed order, does the court require us to set that for hearing, or?
No, not usually. Let me just look it up and see what the status of it is. What day did you say?
November the 10th.
Let me just take a look at it. Nights. We're correct. Let me go ahead and print that out, and I will go ahead and get that scanned in today.
Thank you, Your Honor.
Good morning. This is Kevin Queenan, and we're on a video hearing with Judge Hoffman in Dallas, and Michael Starr, I think, is the lawyer for your firm that represents the non-party that is objected to a deposition. Is he available?
Let me get him for you just one moment.
Thank you.
You're welcome.
How are you guys doing?
Everything's good in our world, Judge. How about yours?
Okay, he said tell you that he's having an issue with his computer, but he's almost on it. He thinks he just about has it figured out.
Gotten there? Okay.
Yeah. So he should be connected.
There we go.
Okay,
I see him.
good. Okay, thank you.
You're welcome.
Hello, Mr. Starr. Mr. Starr, you need to unmute, sir.
I apologize, Your Honor. I had a unanticipated computer issue. I'm sorry I'm late.
No problem. Let's, so we handled the other motion to compel, but you filed a response on this one. So we wanted to kind of hear what you had to say. Did you want to hear their argument again, or?
I've read their argument in the motion, Your Honor, and of course, Warfab's a third party. Their subpoena is not enforceable against Warfab because it did not comply with Rule 205. And so we are willing to comply if they serve appropriate requests under an enforceable subpoena. But as we stated in our response, their subpoena doesn't comply with the rules, and so we would ask the court to deny the motion.
Response?
Yes, Your Honor. The rules are misstated by the non-party. Their complaints are related to 205.2 and 205.3. And so the rules say if we elect to issue a subpoena and not take a deposition, that's when Rule 205.3 would apply. But in this instance, we did serve a subpoena and a notice of deposition for a witness for that company. Therefore, 205.3 doesn't apply. And then, and so the second, because 205.2 in the last sentence says you have to give a pre-notice of a deposition under 205.3. But again, we proceeded outside the realm of 205.3 because we asked for a deposition and the documents. And so we don't think their objection is valid. They failed to make that objection at the time of the response, which again was timely. I mean, if they're going to take a hyper-technical view of the rules, they were late in their response, and it's not my primary argument. I think I have a better argument than that, but I mean, they were 3 minutes late getting a response over to us in connection with this.
Okay, I just pulled out the rule. Can I go through your argument again on 205.3?
Yes, Your Honor. So 205.3 applies if you're going to send a subpoena to a non-party and not ask for a deposition.
Okay.
And so we're not proceeding under that rule because we sent a subpoena and a deposition. And their argument that we were required to give the pre-notice under 205.2, the last sentence says that you've got to give a notice 10 days before you serve the subpoena if you're proceeding under 205.3.
Your argument is you're not proceeding under 205.3.
Right, because I asked for a deposition and asked for the documents.
Okay, response?
Judge, we don't think the deposition that they asked for, I mean, they did ask for an oral deposition. That is true. The topics that they said they wanted to take an oral deposition on related to a search for these documents. And I guess our position is that doesn't really seem to be how we would interpret that Rule 205.2 and .3 were designed to apply here. They didn't even say that they wanted to take an oral deposition to prove up the records as business records. It was not a typical records custodian deposition that they noticed. And so while it is true that they noticed an oral deposition, the topics that are listed almost seem like an attempt to, I guess, get around the requirements of giving us notice on the subpoena. I would also add, Your Honor, that this does sound like a hyper-technical argument, but it seems to me that third parties who are not parties to the litigation ought to be the compliance with the rules that might not otherwise apply if we were in the normal discovery process with parties to litigation. I would also point out that in our response, we made alternative arguments that while Mr. Keenan may not have received the objection, we filed an objection before the 10 o'clock deadline with the facility where he purported, the law office here in Longview, where he purported to have this oral deposition taken, and almost immediately after that sent a copy to him. So this does seem to be, his approach does seem to be what I would call hyper-technical, and I I would argue that's not really appropriate under these circumstances with a third party, especially with requests that we did object to that are a fishing expedition. Throw open your employment files and let us see everything that's in them for a number of people, and hopefully we'll find something that is useful to us in our third party injury lawsuit. So we'd ask the court to deny the motion. If the court feels like that we should be required to respond to the subpoena, we would ask that the requests be refined in a way that identify particular types of documents so that we can respond without confidentiality issues for these employees and without being required to just.
Why don't we do this? I'll go ahead and order the documents be produced, but I do share your concerns. I don't want you to share confidential information involving the employees. Why don't you guys confer? If you can come up with an agreed order, great. Just submit the agreed order. If you can't come, or at least agreed as the form order. If you can't agree, then why don't you come back to this link at 1:30? We have another hearing at 1:30. That should hopefully give you enough time to handle this, and we can hear whatever further arguments you have on that point. How does that sound to everyone?
That works.
That'll
for me,
work for us, Judge.
And Mr. Queenan, if you do get an agreement from Mr. Starr, then go ahead and submit the an agreed as to form order, preferably today if you can, because I'm going to be going out of town. So. And I'd like to be able to sign it by tomorrow.
Sounds good, Judge. Do we have any time constraints? Are you leaving? I mean, can we get it to you by 3 or 4 o'clock, or I don't want to miss you, huh?
To me, I'm going to go in on Saturday to check my orders. So as long as you get it to Rhonda. Rhonda, what time are you leaving today? I don't know. She's not there. So why don't we do, let me see. She says, should we leave it at 5 today? So just get it to her before 5, email Rhonda as well as e-file it, and I'll try to sign it tomorrow. Otherwise, it may be a couple weeks.
That sounds good, Your Honor.
Okay. Anything else, guys?
Not at this time.
Not from us.
All right. Thank you. You have a great day. Happy holidays.
Thank you.
Does that mean that you're going to need me back at 1:30?
Yeah, just in case. It's a foreclosure docket, so you probably won't need to be there very long. Do you have a conflict or?
Well, I had gotten a text from my daughter. My little baby is sick, so I don't know if they're going to have to go in or not.
Why don't you just not come in, or don't worry about it? And if we need a record, then I'll tell them to help to come back.
Okay, then I'll go ahead and check in with her.
Yeah, no, you don't need to come back at all. We'll just work it out.
Okay.
So,
Thank you.
all right. I will see you, I guess, on wait a minute. Today's Friday. We'll see you on Monday. Our docket looks really short on Monday. So, and then that'll be the only thing we have next week.
Okay. All right. I'll see you Monday. Have a good weekend.
Thanks. Thank you. Nancy, Rhonda, we'll see you back at 1:30. And Julie and Josh, I guess we'll see you. Are we going to see you back at 1:30?
Yes, sir.
I'll be back too, Judge.
Oh, Josh, I talked to your roommate, I think, Maximilian. Is that right? Oh, bye,
Yes,
Nancy.
sir. Yes, sir. Max was talking to me about that this morning. Actually, he called me a couple days before, and he had seen the memo and such, and he walked in on a couple of the hearings during or earlier on in the quarter, and he asked how I liked it, and I said I loved it. I've learned so much, and it's a great networking opportunity. And Max was like, "Oh, I need to get on that immediately." So he did, and he told me this morning that he got it. So he was pretty thrilled about that.
Good, good. Do you know Reagan Smith?
Yes, I have. I'm actually on the business transaction, or I'm on the transactional team with her.
I think she's going to be working in the spring as well. So, okay, guys. Well, we'll see you back at 1:30, and I will see you then. Okay, guys.
Yes, sir. Sounds good. Thank you.
All right. Bye-bye.